Dana Kirby.
Alex Jablowski for the people.
Good morning again, Your Honor. Susan Longsworth on behalf of Ms. Kirby. Ms. Kirby, can you please state your name for the judge?
Dana Kirby.
Got it. Okay. What are we doing?
Your Honor, I did file a motion to suppress that I believe could be heard alongside a preliminary examination. So we would request the matter be scheduled for a joint preliminary examination and motion to suppress.
Have the people answered?
Not as of today.
I haven't answered yet, Judge. I just got this week, as I recall.
All right. So if I set it for the 17th, you'll have a response in?
Yes.
Prior to that date. All right. So I'll set the motion to suppress and preliminary examination. I'll set that for October 17th, 2023, 9 a.m. That is before Judge Valvo.
Thank you, Your Honor.
Thank you.
Thank you.
Your Honor, is that also at the service center?
Yes, it is.
Okay, thank you.
And typically, counsel, the motion to suppress, well, there's going to have to be evidence heard.
It would be the same witnesses that would testify.
Continue to 17 for both. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Trey McAllister.
Alex Jablowski for the people.
Good morning.
Morning, Your Honor. Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. McAllister. He is present from the jail.
Yes, he is.
Yes,
Sir,
he is.
state your name.
My name is Trey McAllister.
Thank you. All right, what are we doing?
Your Honor, I met with Mr. McAllister earlier this week and also contacted Mr. Chabalowski, and I believe we're going to be doing a referral to the mental health court. Is that something you're still interested in, Mr. McAllister?
Yes, of course.
Okay. So I would be making that request. I do have the paperwork filled out to send to the court. And I would ask to address bond.
So you're going to adjourn this matter?
Yes, please.
Probable cause will be adjourned with the referral if you get that over to me so we can start that process. I'll adjourn this out to October 26, 2023, 9 a.m. As to bond, briefly.
Your Honor, Mr. McAllister is hoping that the court would consider releasing him on a personal bond. He has spent approximately a week in jail. He does have support in the community. He is already working with, excuse me, just one moment. He's already working with CMH previously, and he has employment through Ground Cover News. He also does landscaping and stocking. So he does have employment and employable skills once he is released. He promises that he will appear via Zoom, and he has the capability to do that. And he has a residence in Ann Arbor, so he is local.
Here's the problem. He was initially given a personal recognizance bond. He was referred to community corrections. I then received a bond violation report on September 18th. His arraignment occurred September 12th. He did not appear at community corrections, did not report to community corrections as previously ordered. And then further after that, he then failed to appear for the preliminary exam or for the probable cause conference. So he hasn't, quite frankly, appeared for anything up until today and is appearing in custody.
Well, that is absolutely true, Judge. But he does have the support of Avalon. He has a case manager.
How did he come in custody?
He was
Pulled over on my warrant.
yes.
Yeah. Okay. That's what I thought. Motion for bond reduction.
Doesn't anything.
All right. Thank you, Judge.
Thank you.
Thank you, Judge.
Thank
Thank you, Judge.
Court calls case People versus Tamar Young.
Alex Jablowski for the people.
Sam Bernstein for Mr. Young, Your Honor. Mr. Young, could you please state your name for the court?
Mar Young.
the court has received a meter request. Any objection?
No, Your Honor.
All right. Ms. Longsworth?
I apologize, Your Honor.
It's okay. And this is on Mr. Young.
Thank you, Your Honor. And did Your Honor grant Mr. Bernstein's motion to withdraw?
Yes, I will grant his motion to withdraw. Are you withdrawing on both or just one?
I think both make sense, Your Honor.
Well, is there a basis on both or?
No, it's just the higher severity one where the conflict of interest exists.
On the open murder. So I'll grant I'm only granting it then on the case ending in one. Well, why do I have? Oh. No, I'm not going to do it that way. So the open murder case, which is the case ending in, which one is it? Ending in 1433. I will grant the motion to withdraw. On that case, you're going to have to stay on the other. I don't have a basis for the withdrawal in that case. So whether people think that makes sense or not, I'm not going to do that.
Thank you, Your Honor.
All right. So what are we doing in these cases?
Your Honor, as to the open murder case, I would ask for an adjournment in order to review discovery. I was provided with a significant amount of discovery from Mr. Bernstein and the prosecutor's office, and I need to have the opportunity to review that and discuss that with my client.
So how much time?
Your Honor, if we could have a month, I'd appreciate that.
All right. What are we doing on the other matter?
I would ask that it tag along with Ms. Longsworth's case, Your Honor.
Probable cause conference in these cases will be adjourned then to November 2nd, 2023, 9 a.m. Bond will continue as respectively and denied in each of these cases.
Thank you, Your Honor.
Thank you.
Thank you. So you got that I granted it on one and not on the other, and I'm going to need a new order from the office over there. Make sure. Court does call the case of the people versus Patrick Petterpin.
No public use on behalf of people. First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Petterpin. Mr. Petterpin, can you state your name, please?
Patrick Petterpin.
What are we doing?
Your Honor, in these cases, I'm asking for an adjournment. We had requested some videos. I've received videos in 2 of the files. I'm asking for videos in the other 2. If we can have a 2-week adjournment to get those videos and share them with Mr. Petterpin. And he's also asking to address bond.
Briefly, you can go
Thank
ahead
you,
and
Your
address bond. I'll adjourn these out to October 19th. Go ahead.
Thank you, Your Honor. Mr. Petterpin's been in custody since September 5th. He does have a PR bond on the 1319, which is the larceny matter. He indicates to me that he does have a OWI case before Your Honor in 14-1. And in that matter, he was granted a personal bond with the GPS tether. He's yet to receive that tether. So he's not yet been released on that case either. He does have a job that's being held open for him at Saladino Construction in Ann Arbor. He's asking the court to consider personal bonds, especially in light of the fact that he will be on GPS tether if released.
Response.
Yes, Your Honor. In these cases, I requested $25,000 cash surety on each, which I believe is what he was granted on the fleeing cases. Additionally, yesterday, I just charged this defendant with another fleeing third, and I requested an additional $25,000 on that file. There's a lot of cases. He usually has warrants out for his arrest, and when the police try to stop him or take him into custody for those arrests, he flees. There's one of these cases that's up for today. He has fled. The pursuit has to be terminated. A different case where he's ultimately able to be taken into custody, he starts talking to the police about the prior fleeing and says to them, I don't know if you were involved in that brigade. And they weren't, so he's making statements that are consistent with the other fleeing, despite that they don't otherwise even know about it. One case in particular that's up for today, it's an entirely different situation, but it also ultimately has to be terminated. Police are called out to a parking lot. The defendant's in the driver's seat of the car. He's shirtless, profusely sweating, acting erratic. They ask him to get out of the car. He says, just let me put a shirt on. He proceeds to roll up the windows and peel out of the parking lot, taking them on a chase. I don't know what else to say other than he has 4 open fleeing cases now, all of which I've requested $25,000 cash surety on him.
And I think he poses a danger. I think he poses a danger to the community. Motion for bond reduction tonight. Bond will continue October 19th, 2023, 9 a.m. on all matters. Thank you.
Could you repeat that, Your Honor? I'm having a hard time hearing you.
Which part?
I guess
The motion for bond reduction has been denied. I've set these matters out as your counsel has requested, a couple weeks to the 19th at 9 a.m.
Okay, now, as far as the bond, how many bonds do I have, or how many charges do I have, which you're addressing today?
Well, you have 4, and there's another one on the way.
Okay, so you said there's another
Got to
one.
be 5.
Again?
Got to be 5. That doesn't include the ones that you have the other bonds on. So we 6 or 7, something like that.
So those are the ones that have yet to be arraigned on as well?
Well, there's one that's coming. I don't think you've been arraigned on that one.
Okay, and so with what I have been arraigned on, what are my current bonds? I know that I have at least 2 that are 25,000, if I'm not mistaken.
What are you asking?
I'm trying to get an idea of the bond, the amount of money for the bonds, because I know that if there are multiple charges.
Right now, your bond on case ending in 5666, that bond is set. You have his bonds laid out for now. I've got it, I think, right here. The bond on that case is $25,000 cash surety. On your other matter, the case ending in 1318, your bond is also set in the amount of $25,000 cash surety. On the case ending in 1319, your bond is set in the amount of $5,000 personal recognizance. On the other case ending in 1041, your bond is set. Do you have that one? That one is set at 1,010%. Those are the bonds that I have before me.
Okay. So that was 2 at 25,000, 1 at 5,000, and 1 at 1,000 cash surety, a couple PRs. And then you're letting me know that there will be an additional charge where I get to be arraigned.
Yeah, there's another one to be arraigned, so that number may change.
Okay. I know that I was granted a PR for one of the charges with a $25,000 bond from you. And
Oh, I know.
Okay. So I know that you granted me that bond pending I get a GPS tether, and I believe that GPS tether would be able to keep track of where I am and so forth. So I'm just asking, asking you again, please, if you
You're asking the same thing that your attorney so eloquently laid out to me that you're now just rehashing, and I denied it.
Yes, sir. Yes, sir. Well, I mean, I don't know what else I should do. You know what I mean? If that's something that I would like, and I would like to keep my employment. And I know that I myself don't pose the threat to the community, which the prosecution.
Well, when you run around high speed chasing, and all of this is alleged, and running away from the police, this court believes you do pose a risk to the community. And that's how I laid out my response to your counsel's argument.
I understand that. And I'm just, this is just my rebuttal, Your Honor. So
you're rebutting my order.
Well, I'm just rebuttaling.
Yeah, that's
to
not
stand
gonna
up for
work.
myself.
But you can go for it.
Of course.
It's not going to work.
Okay. Well, what was that?
Ms. Anderson, anytime you want to step in, you can. I mean,
Your Honor, I think I've said all that has needed to be said, and Mr. Petterpin has repeated it, and Your Honor has denied it twice. I'm ready to move on. Thank you.
All right.
What were those dates? Though?
Thank you.
October 19th. Okay.
Court calls the case. People versus Christian Reyes.
Nicole Hughes on behalf of the people.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Reyes this morning. I am staying in for his attorney of record, Christina Constantino.
All right. And we had a previous, is Mr. Reyes present? Please state your name, sir.
Christian Benitez Reyes.
And you have no objection to Ms. Rushing stepping in for Ms. Constantino at this point?
Oh, she's not able to be here today?
She was here earlier.
She went into
counsel-
another courtroom.
Yes.
I mean, if it's possible.
Mr. Reyes, it's just for today's hearing.
Okay, if it's possible, I'd rather wait, but it's okay.
You what?
I said, if it's possible, I'd rather wait for my lawyer, but.
Okay. All right. Well, she's what? She's in a murder exam, sir.
Okay, so today's just the.
Well, here's what happened. Earlier today, because there are co-defendants on the case, Ms. Constantino was here. When I called one of the other co-defendants' cases, they were setting it for a preliminary examination. All right? I spoke on the record with Ms. Constantino as well as Ms. Longsworth and the other attorney that was handling, Mr. Bernstein, I think, that was handling that matter. Everyone agreed that a preliminary examination would be set for October 17th. All right. From what I understand, and I don't know this for sure, Ms. Constantino went into another exam.
754873.
Can we? Ms. Constantino went into another exam in another courtroom. Ms. Rushing is now appearing, and my belief, although she hasn't said so, is that she would be asking that the court set the preliminary examination for October 17th.
Okay, that's fine. I just wanted to make sure.
That is correct, Judge.
All right. So you don't have any objection to Ms. Rushing stepping in to do that. Ms. Constantino has done what she was going to do. She just did it earlier before we could bring you to the screen. Okay. All right. Given all of that, preliminary examination will be set in person October 17th, 2023, 9 a.m. And that is before me. Defendant's bond will continue as denied. Thank you.
Thank you so much, Judge.
Thank you.
Can I recall Mr. Lockwood, his new attorney is up?
Is he up? He is. Court recalls the case, People versus Lockwood. Recall.
Laura Willenberg on behalf of the people.
Good morning, Your Honor. Marcia Creation on behalf of Mr. Lockwood, or soon to be appointed on behalf of Mr. Lockwood.
Yes, I have signed the order.
Your Honor, I just received discovery via email 3 minutes ago. I'm asking for an adjournment in this matter of approximately 2 weeks.
Mr. Lockwood, can you state your name, please, sir?
My name is Gary Lockwood.
Thank you. All right. You have your new attorney on the case with the PD withdrawing. I'll adjourn this matter out to October 19th, 2023, 9 a.m. Bond will continue. All right, sir.
Yes, sir.
Thank you.
Thank you.
Court calls the case, People versus Esmond Britt.
Nicole Hughes on behalf of the people.
Your Honor, Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Britt, who is present.
Mr. Britt, state your name.
Esmond Britt.
All right, what are we doing?
Your Honor, we are waiting on the results of a mental health court screening. He has been screened, I believe. We're just waiting to see whether or not they accept him. So we would need to adjourn, and I would ask to address a bond condition.
Are they expected to give an answer soon, or we don't know? All
I
right.
don't- I don't know.
We do October 26, 2023, 9 a.m. Yes, as to the bond condition.
Your Honor, I know previously it was requested that his tether location be changed back to his home with his wife and children. Previously there was not a letter from his wife, and we do now have a letter from his wife requesting that he be allowed to come back home, be tethered to the home. She does have 5 children under the age of 13, so she's got a lot and needs his help at home. He has been doing well since his release for the past 41 days. He completed outpatient, has continued with therapy as the aftercare that was recommended from that program. He goes there weekly and is also taking his medications as ordered. His entire family is basically making this request to allow him to return home. And I understand that Ms. Hughes did not agree. So I know she will respond to that, but I just wanted the court to know that Mr. Britt's wife has written a letter requesting that he be allowed to return home.
Response again.
Thank you. The last time we were here, a different public defender, I believe it was, requested again that he be able to return home. At that time, I did have a letter written by his guardian, who's his sister, that I understand to be signed by his wife. Since then, Ms. Noveski has forwarded me a letter written. From what I understand, again, it's a writing. I have not confirmed with the wife that she actually wrote and signed these documents. I am still opposed to the defendant returning home. Last we were here, I put on the record that had I known that that the defendant would be turning around to ask that he go back to the marital home, I would have never agreed to his release from custody. The defendant's wife was interviewed as part of this investigation. This is the case where the defendant almost caused a gas station to blow up. I mean, he had set fires around the gas station pumps. He had taped up a butane port, left it lit, poured gas on the ground. People could have been severely injured or killed, frankly. From what I understand, this stems from his mental health issues. Leading up to these events, this is information provided directly from the defendant's wife to the police. The defendant was manic for 2 months leading up to those events. During those 2 months, he was twice hospitalized, medicated, and then returned to the marital home. While he continued to live in the marital home, again, either he stopped taking his medication, was under medicated for whatever reason, he returned to this manic stage, then leading to these events. The wife reported to the police that she was fearful of the defendant, that the children are afraid of him during his manic stage, and that when he was around, she would have their children go and stay with family members to prevent them from being around his erratic behavior. There was at some point a court proceeding in front of Judge Aldzai where the wife was required to testify. I understand that to have been on Zoom. The defendant and the wife must have been sitting beside each other on Zoom because the wife told the police that the defendant was holding her leg under the table and squeezing her thigh tightly, causing her to testify to not tell the truth during her testimony. And she told Judge Aldzai that he was mentally capable of taking care of himself when he wasn't. Because these are things that were going on for months, despite their attempts to stabilize him, and it still led to these events, I do not feel comfortable with him returning home. I want the wife and the children to be protected and safe, but I also don't want him returning to the environment that perhaps led to these events anyway.
Your Honor, I would just point out that one of the stress triggers that led to this manic episode was his business that he had, and that's no longer an issue. That business is now defunct. So that's one of the main stressors, and that is gone. And since this episode, obviously he has had treatment. He continues to have treatment and medication, and he is compliant with all of those things. So, I mean, how long do we keep him away from his wife and kids? I mean, he's being treated. He hasn't had any episodes. 41 days almost,
Well, here's what I'm going to do. I'm going to, at this point, until I see at least some evaluation or determination from the mental health court, I'm going to deny the request for any change in bond. I'd want to see some more information regarding their evaluation. So at this time, the bond will continue as stated with all of its conditions. The motion for the change is denied. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Joshua Brown.
Nimesh Ganatra, First Assistant Prosecuting Attorney for the People.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Joshua Brown. Mr. Brown, could you unmute and state your name for the record, please?
Joshua Brown.
Okay, we got him. All right, what are we doing?
Your Honor, we are asking for an adjournment in this matter. I have been in negotiations with Mr. Ganatra. I want to put together a mitigation report to submit to Mr. Ganatra.
Without objection, October 26, 2023, 9 a.m. Bond will continue.
Thank you.
Here. Court does call the case of the People versus Jonathan Ward Callahan.
They adjourned it.
Laura Willenberg on behalf of the people.
We're ready in that matter. Glenn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Ward Callahan. Mr. Ward Callahan, please state your name for the record.
State your name.
Ocean.
Mr. Ward Callahan, can you state your name?
Your guys' facility is actually really nice.
They want you to state your name, Mr. Callahan.
That's cool. So kind of just kind of like a spiritual thing going on with my family. So if I could get a request from the judge, or if I could put it in a petition.
All right.
Allow me to, that'd be pretty cool.
Your Honor.
Deputy, that is Mr. Callahan.
It is, Your Honor.
All righty, thank you.
Thank
All right. There's a report in this case. I don't have a copy of the report. Counsel. Here's what we'll do. And I see that the order is here, but I don't have the report. So what I will indicate, if you can send over the report for the court will review that report for purposes of this hearing. My understanding is that the defendant is incompetent, but that he is restorable. Once I review that report, if that is consistent with that, unless there's other evidence, I will sign off on this order.
All right, Your Honor.
All right, and pardon?
I wanted to first verify the prosecution has received a copy of the report.
I have.
All right. So I'm the only one that doesn't have it. So I'll do it this way so that we don't have to bring it up. I'll set a review date out. Give me 90. I'll set a competency review hearing for January 4th, 2023, 9 a.m., 2024, excuse me. If for whatever reason, after review of the report, that being the only evidence, I find that it's not satisfactory for the court to sign the order, then I will reset the hearing.
Okay, then.
Fair enough.
All right. Thank you, Your Honor. I'll send the report.
All right.
All right.
Thank you, Bond. We'll continue.
You're on.
Court calls.